Ladies and gentlemen, thank you very much to be here, and particularly to reconvene after the breakfast. We know that there is a lot of temptation. And so in this panel, we are going to talk about something that has already been mentioned several times. So we pay the fact that we are in the second part. And but if it has been mentioned several times, it means that is very important and pivotal for us. It is very important for the in-house lawyer. We are going to talk about independence and code of ethics. It will be an interesting speech, I hope. And we would like to be a speech that will collect comments and suggestions, because we are entering an important period of Ecla. We are going to, inside the concept of independence, to draft our code of ethics. And it will be presented and discussed tomorrow. So any comments is more than welcome. This will be inside the concept of independence that is a living concept, because initially it was thought to protecting lawyers and their clients from the power of the state, and now which is associated to the protection of the public interest from the lawyers that are perceived from someone too close to their clients. So everything's changed. I leave to Jean Cattaruzza, about which the CV is on the paper, to talk about independence. Thanks.
Thanks, Sergio. Ladies and gentlemen, thank you very much to be here, and indeed to listen to this topic that has already been mentioned by a few speakers before the coffee break. So, but why do we consider independence so important? And yes, how can I move? Well, why do we consider within the executive board of Ecla to promote independence, and more in particularly the setup of a white paper on the independence? Well, all the previous speakers have already warned you for the necessity to work on a national level to enhance in each country the situation of in-house company lawyers. As Ecla, our contribution to this goal is to help our members to build, brick after brick, their whole by giving some recommendation. Of course, we know that the situation is not the same in each country, that some countries are building higher walls than others, that some countries are building quicker than others. This is, of course, not a problem, must be respected, as long as everyone is convinced of the necessity to go in the same direction and to share their success with each other. So, in the next minutes, I will give you a little bit the flavor of the work we are doing at the moment within Ecla, and to share some ideas that still need to grow in the coming month. Why is independence important? Legal privilege, we have talked enough about this. I would like to tell you and to show you that independence must surely not be reduced to a legal privilege. And I have taken another example, a very fresh one indeed, from the Capital Requirement Regulation dated 26th of June 2013. I have the bad luck to work in a bank, so maybe I'm more aware of those specifications than others. So let me introduce briefly this subject to you. You know that one of the functions of the bank is to grant loans to third parties, but at the same time to avoid or try to avoid events like 5 years ago, the regulators have, or the legislator, have said that there must be a balance between, on the one hand, the amount of credit you are granting to counterparties, and on the other hand, the capital from the credit institution. And so you cannot grant loan, let's say, till the end of the day for very huge amounts if you do not have the adequate level of capital. Of course, not all loans are supposed to, let's say, to the amount of capital you need for a loan can depend on the quality of the counterparty. For example, you will need less capital for a state than for an individual or a corporate, and you will also need less capital for a secured loan than for a non-secured loan, which seems rather obvious. But, okay, fine if a bank pretends that all the loans are secured. Maybe it's a little bit short notice, and we should be sure that those securities those credit protection are really valid and enforceable. And in this perspective, you have this Article 194 of the CCR4, where it is written, it is in bold, then the credit institution, the lending institution, need to provide, upon request of the competent authority, the most recent version of the independent, written, and reasoned legal opinion that it used to establish that the credit protection is a valid one. And so the question, can we, as in-house company lawyer, give this independent legal opinion or not? And of course, here we are really far from concepts, we are really far from the recognition from the profession as such. We are speaking about really important economical consequences of our statute. Because you can imagine that if for each legal opinion we are supposed to give, we need to go to external legal counsel, well, this will have, let's say, the increase of our costs as a consequence, which is a little bit not in line with the cost containment, which are towards very popular at this moment in the bank world. So this is just one example. I'm sure we can find other examples in other fields, but this is really to show you that when we are speaking about independent advice, independent legal opinion, we are talking about very concrete issues. Independence guarantees that a company can be confident that his or her lawyer will provide legal assistance in a proper manner, including written advice without fear of interference or sanction by the government or other interests. And this is also an evolution we have to mention. I think that 20 years ago we could work, let's say, in a more trusty environment. We knew each other with the management, and we could, let's say, have oral advice. I think that this time is over. At this moment in time, we are supposed to confirm all our advice in writing, and this is, I think, something very good for us, to protect ourselves that, okay, we have said this and not that. It's good for our company because it can rely on something in writing, and also when we have to do reporting, which is also something a lot of you are familiar with, and of course it is compulsory to have written advice. And then if a company considers that the legal department, the setup of a legal department, or even a solo legal advisor, because this is also a reality in a lot of companies, we just have one lawyer. if you make this investment, because it is an investment to have in-house company lawyers, you need to have a return, and the return is to put everything in place so that you are sure that the advice given are of quality and are not, let's say, influenced by fear or things like that. And then the question, are we independent? We have already answered to that question. The answer is indeed not linked with our labor statute. Independence is an intellectual mindset. This has been said before me. But what is important to stress here is that this independence needs to receive a clear framework to be sure that it will be effective. And this framework must include the adherence to a professional association with effective deontological rules. And here again, we know that the situation is not the same from country to country, but what is important is that on a national level, everyone is working on the same direction, respecting, again, the possible difference of speediness between those countries. I think that this is not new to you, so maybe I will elaborate a little bit more on the possible evidences of our independence within the company, because I think this is really a twofold process. From the National Association, we can really expect that they build a framework that will encourage the in-house company lawyers to be independent. But on the other hand, for sure, the company must also establish a framework that give evidence of the fact that they respect their in-house company lawyers and put in place measures that will help them to act as independent. Those are, of course, just examples, and I am aware that it will be easier to put them in place in a large company than in a small one. In small middle enterprises, where in-house company lawyers are often also in charge of other domains of activities, more mixed functions, it is, of course, more difficult to put in place what can be considered as a heavier structure, that's for sure. And this is also to be taken into account, so maybe it will be interesting afterwards to hear the voice of a solo lawyer to maybe express some nuance to what I will say. But coming back maybe to some suggestions, first of all, a sound governance within the company, including eventually the setup of a whistleblower procedure, so that if I find difficulties to exercise my function in a proper way, I can express to, let's say, a neutral party the difficulties I meet, because at the end, well, if I'm not respected by the others, the problem is not me. The problem is the others, and we have to put measures in place to address this in a proper way. Also, in larger companies, what you find is more frequently the dual structure. You have the functional one and the hierarchical one. The functional ones, so then you speak to other lawyers who are in the mother company, and you report to them all issues you can have if you have difficulties to find your way in your own company. The functional line normally is there to help you, and the fact that in case of issue you can escalate the issue to a high level where you still speak to a legal advisor, to the general counsel, I think is something very important for the respect of your independence. Third suggestion, no hierarchical link with business people. So this means that you should, as a head legal department, have, first of all, a direct access to the board in case of issues. If you find that the general manager is maybe reluctant to take some important advice into account, access to the board, like the case, for example, for the auditor. So why not for the legal, for the general counsel? And in the reporting line, please avoid to report to a business officer. If you have in place a chief risk officer, I should say it is a more natural way to put the link. If it is not the case, the CEO should, I think, be the normal partner to report to. I have seen the slide saying that we need to be paid well. Yes, I can agree with that. But maybe I should like to add a nuance that I'm not sure that variable remuneration linked to the success of a transaction or linked to profits are really in line with our statute. I think that we really need to avoid to be influenced in our judgment by the fact that bonuses could be linked with the success of a transaction. We are business partners, as we said, but we need to keep a certain distance towards the realization of a transaction, and that's why I think that a model where variable remuneration should be linked with the success of a transaction is not the most appropriate one. I repeat, these are only some recommendations. I surely do not pretend that we have to see all those points in all companies. I repeat that I fully understand that for small, medium enterprises, maybe they have to be more creative to find other measures that are more compatible with the scale of those companies, but that also give to the world the clear evidence of the fact that the company respects the independence of the lawyer, even if it is a solo lawyer. These are, I think, some ideas I would like to share with you in maybe the coming minutes after Sergio's speech.
Thank you. Thank you, Jean. Thank you very much, Jean. And now, continuing on this way, I would like to tell you that tomorrow we are going to have a discussion inside the Ecla General Assembly of something that took a lot of time to reach, and we have not reached yet. It's 30 years that we are thinking to have a common concept of company lawyer. When our predecessors start Ecla, I'm sure that already at that time they were thinking to have to be together, to have a common concept of what is it to be in-house lawyer. Now, the base to understand what we are is definitely to share a professional identity. How to do that? If it's not possible to do it from the bottom, better to do it from the top and then go down, is to share the concept of ethics. So what are the principles that we share all around Europe? What are the principles on which everybody of us could recognize themselves, could be proud of it, part of this, not association, but of this profession? Could be feel themselves recognized as a professional equal in all Europe. as are the engineers, as are the doctors. There are places in Europe where the in-house lawyer is not recognized at all as a profession, does not exist. And so what we want to do tomorrow, what we will try to do tomorrow, is to share this, to reach the common sense of ethics for the in-house lawyer. How we have done this? First, we have analyzed, if I could have the other slides, we have analyzed, we made a comparative study of all the ethics code, mostly all of the ethics code that are in our association, that give you an idea of the work that we have done. Try to look for each concept that is contained in each code of ethics where the code is already present. And then we try to make a synthesis where everybody could recognize themselves and where particularly nobody could feel in contrast with. There are differences among us. There are some more lucky countries where the in-house lawyer is already, the profession is already properly established. And we aim all to be at that level. But there are other countries where this privilege, I'm not talking of the legal privilege, but the privilege to be recognized as a profession is not yet there. So how could we, taking what has been said in the first part of our meeting, how could we go to the National Association of Employees or Industrial Association to say, this is what we are, that is what we want to be, that is the service that we want, that we can provide to you. That is the reason why we could have, it would be appropriate, it would be in your convenience that we have the legal privilege, because in the interest of the company itself, in the interest of to be also the American lawyers, that when they sent us something with a legal privilege, they could be reasonably sure that what we are going to receive will not lose the legal privilege. So that is the work that we are going to do tomorrow. Could you switch? So it's an opportunity. I see this as an opportunity, and I hope that my colleague, I'm sure that my colleague will work hard to find a common point where we could share common principle and be recognized as one entity, regardless the country we work by the European institution. Also will be the base on which we could go to the European institution, as all the other professions. So, as I said before, we have done a comparative study, could be done better. Maybe there is some country that is missed. Perfect, let's do it, let's introduce, let's compare it. And try to avoid contracts, because that is what has been the showstopper in the first 30 years. Now the feeling is that the situation is more mature. There are feelings around the table that recognize the need of a document that will, where everybody could recognize themselves. And so that's why we have done this work, and that's why we are optimists. Important concept. We are not going to present a document that intends to prevail the existing national code. Also, the way on which we are going to enforce this has to be agreed upon ourselves. So it will be mandatory. There will be a window on which the country that does not have exactly this code could join this, could adopt this code. Could be just a state of principle where all the countries, all the national associations could rely upon, could take inspiration. It's a matter of discussion, and it will be decided tomorrow, I hope. And particularly, there are national that association that does not have yet a code of ethics. So for that, it will be a very good example, it will be a very good driver to adopt in the line with the European Association. So what we are going to do is to offer an instrument, to offer a tool to feel European in-house lawyer recognized to have the same profession all around Europe. I hope that we'll succeed. Thank you very much. Now I'm pleased to pass the word to our colleague Pierre Laporte, that very kindly accept to step in instead of Kate Carr. And Pierre will tell us about French experience from code ethics and independence point of view. Thanks, Pierre.